welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular episode, I'd like to talk a little bit about waivers of crimes. Now, I have many videos on different kinds of waivers, and I would like to talk today about a particular waiver that is not usual and that is not submitted very often but is available, and you should be aware it's available in case it applies to you. So the first things first, this waiver applies, number one, the crime. It doesn't apply to every crime, but the crime was committed more than 15 years ago. Okay? And if the crime was committed more than 15 years ago, then you can apply for this kind of waiver. Now, first things first, the burden of proof needed to get this waiver, the evidence which you submit, the hardship that has to be shown, all of that is easier with a waiver where the crime is 15 years or older. Okay, that's just a fact. If you commit a crime, and you're eligible for a waiver, you can, prepare and submit the waiver the day after you're done serving your time. But that's going to be a harder, normal waiver that has to go forward. So first of all, what crimes are eligible that would fall under this particular 15-year waiver rule? Well, first would be a single offense of simple possession of 30 grams or less of marijuana. Now, keep in mind that you can certainly go to all these states that are legalizing marijuana, but it's the state law that's legalizing marijuana, not federal law. So it's still illegal under federal law and still makes you inadmissible. Okay, so if you have, again, a single simple possession of 30 grams or less of marijuana that's 15 years or older, this particular waiver will apply. Also, you could have multiple convictions, string of convictions that would be normally eligible if you did it in before the 15 years for what's called a 212H criminal waiver. But again, if they're more than 15 years old, you get to use this 15-year waiver. The next crime which you would be eligible would be prostitution. So again, if there's a prostitution crime that's over 15 years, then it will fall in this category as well. Next, crimes involving moral turpitude, or CIMTs. There's a lot of them out there, and they make people inadmissible all the time. So if there is a CIMT that's over 15 years old, that will fall into this category. And then finally, crimes committed by an applicant who has asserted immunity. Okay, I can tell you those don't come up very often, but that does fall in as well. Now, what do you need to prove? What do you need to show on this particular waiver in order to get it approved, or to have a better chance of getting it approved? Well, of course, first and most obviously, you need to show the crime was committed more than 15 years before the visa application submitted. So, if it's let's say you're right on the cusp of the 15 years, and let's say you want to submit the application and it's 14 years and 3 months. Well, if you have to do a normal waiver versus the 15-year waiver, it might be in your benefit to wait for that time so that you get the waiver that's easier to get approved. Because, as you might know, unless the waiver is approved, you're not coming in. Okay, that's the bottom line. So in essence, the waivers are the most important part of the whole visa process if you're inadmissible. Okay, so then you also have to show that your admission to the U.S. would not be contrary to the national welfare, safety, or security of the United States. Generally, this is pretty easy to show. Obviously with the political climate today, there could be arguments made otherwise, but if you don't fall within that category, this doesn't take a terribly expansive argument or a lot of evidence to show that. And then The next and final requirement would be that you have been rehabilitated. So there's all kinds of ways of showing that. Okay, I mean, one thing, if you haven't had a crime in 15 years, that by itself shows rehabilitation. But let's say that you did have the possession crime, marijuana. Did you go to any, AA type meetings for, drug addiction? And have you done volunteer work? Have you seen counseling? Let's say you had a domestic violence charge. Have you had anger management classes, things like that. And also, we can add a psychological evaluation to show that there's been rehabilitation. So, there's all kinds of ways of showing that. So, those essentially are the elements. Now, you might notice that one of the biggest things that you don't need to show is extreme hardship to the qualifying relative, which again usually is either the U.S. citizen or lawful permanent resident, spouse or parent, and in some cases, children. That's usually the hardest part of a waiver, and that's usually the reason it gets denied, because they will say, well, that's just normal hardship, is not extreme hardship. So the fact you don't have that element in necessary to prove if the crime is over 15 years by itself is a big incentive to use this kind of waiver. A lot of times people still submit the regular waivers after 15 years, and it's not immigration's place to say, well, you don't really need to submit this one. You can submit the 15-year waiver. They don't. They just adjudicate what's in front of them, and then they end up getting denied because they can't prove the hardship, which they didn't need to do in the first place if they submitted the right waiver. So all in all, it's a good waiver if you fall under the particular facts of this waiver. If you like the video, click like, subscribe, and more in the coming videos. Thank you.